Hello, everyone. Welcome to the Environmental Law Institute's sixth and final session of Summer School 2026, Environmental Justice. My name is Madison Calhoun, and I'm the Environmental Law Institute's Education Programming Attorney. We are so excited to conclude this year's Summer School series with all of you today. If you are not familiar with ELI, we are an internationally recognized, nonpartisan research, publishing, and education center working to strengthen environmental protection by improving law and governance worldwide. We convene professionals representing divergent perspectives on important policy questions to build bridges, foster common understanding, and explore areas of ultimate agreement. The opinions and positions expressed by any program speaker today are theirs alone and do not reflect the views of the Environmental Law Institute. Each summer, ELI convenes a complimentary seminar series that offers an introduction to the legal and policy foundations of environmental protection in the United States. This is our final session of this year's series. Before we get started with today's program, I want to share just a few quick logistical notes. First, if you missed any previous sessions, you can find them on the ELI website or on ELI's YouTube page. We will drop a link to that in the chat soon. I want to thank our fantastic speakers for taking the time out of their busy schedules to prepare these presentations. You can find links to their full biographies as well as PDFs of the PowerPoint slides that they'll be using throughout the webinar on the event webpage. We will also drop a link to that in the chat. Like the previous sessions of summer school, today's webinar will be recorded. The recording will be publicly available, and it will be posted to the event webpage and ELI's YouTube page within a few business days. Additionally, we will be saving time at the end of the webinar for audience questions. Please submit any questions that you have using Zoom's Q&A function. We encourage you to use the chat to share any observations, comments, and resources, but please be aware that we will be pulling discussion questions from the Q&A box. And now I will introduce our fantastic moderator, Kristine Perry. Kristine is a senior attorney at the Environmental Law Institute. She works primarily on international issues with a focus on Latin America. Kristine leads ELI's work on environmental defenders. She has experience in judicial training on deforestation issues in Colombia, environmental crimes in Peru, migration with dignity, as well as enforcement issues more broadly. Kristine, I will hand things over to you. Thank you so much.
Thank you, Madison, and it's wonderful to be here with all of you. I am going to go ahead and introduce our fabulous speakers and let you know kind of the run of show that each speaker will present, and then we'll leave about 30 minutes at the end of the program for any audience questions. So as questions come up, please put them in the Q&A chat. We probably won't be able to get to everyone's questions, but I will try my best to make sure we get through the bulk of them. So first joining us is Stacey Halliday. Stacey Halliday is a partner in the Washington, D.C. office of Arnold and Porter, where she is a member of the environmental practice and serves as co-chair of the firm's ESG working group. Her practice combines deep experience in traditional environmental regulatory, enforcement, and transactional matters, including a sustained focus on environmental justice, where she advises clients across industries, including automotive, consumer products, retail, manufacturing, and airlines, on the rapidly evolving patchwork of state EJ statutes, permitting and cumulative impact requirements, and community engagement strategies. She has closely tracked the shift in EJ policy and advocacy from the federal to state and local level, bringing her prior experience as special counsel in the U.S. Environmental Protection Agency's Office of General Counsel to bear to help clients build environmental justice programs, policies, and enterprise-wide strategies. Stacey regularly produces client-ready comparative analyses, compliance trackers, and presentations on these emerging issues for both regulated entities and the broader legal community. She is also a proud member of ELI's board and alumni of the Howard University School of Law. Thank you for being here, Stacey. And now we have Chandra Taylor-Sawyer. Chandra is a senior attorney in the Southern Environmental Law Center's Chapel Hill office, specializing in water quality and environmental justice issues. She first began her career at SELC in 2006, following years of practice as a consumer protections attorney. She also serves as an adjunct professor at the University of North Carolina School of Law and on the board of the North Carolina Justice Center. Chandra has led work in North Carolina to force cleanups at contaminated industrial sites, stop water pollution threatening North Carolina communities, and shape transit and landfill policies. In 2007, she helped lead the overhaul of North Carolina's Solid Waste Management Act in order to protect lower wealth communities and communities of color, as well as natural resources from bearing disproportional harm from landfill siting. Thank you so much for being here. And without further ado, I'd like to turn it over to our wonderful panelists.
Thanks, Kristine. And I'm really excited to talk with you all today about environmental justice, what it is, the advocacy landscape, and the path forward. Next slide, please. So even though environmental justice is no longer described by a federal executive order, there are several reasons why poor people and people who have suffered from systemic inequity are more harmed and less able to recover from pollution and extreme weather events. So even though we'll go through several slides that show the regulatory rollbacks, the executive orders that have actually been formed to do away with environmental justice directives, I think it's important to ground the discussion in how and why poor people and people who have suffered from systemic inequity are less able to recover. Those same groups are less able to move away from pollution, are less able to protect themselves from the brunt of extreme weather events, receive less aid from insurance and government sources after extreme weather events, have less political power to influence the siting of polluting facilities, have less access to acute and preventative health care, and are overall less able to recover. Next slide, please. So poor communities, especially communities of color, disproportionately bear the burdens of pollution, including the immediate burdens of global climate change. So environmental injustice is still a problem to be faced, even if there are fewer federal directives for achieving environmental justice. Next slide, please. So these next few slides will detail several of the federal executive orders and administrative actions that are related to eliminating an explicit environmental justice directive. The policy statement on the treatment of environmental justice matters in nuclear in the NRC regulatory and licensing actions. That policy statement announcing that NRC withdraws its EJ policy statement was published in August. That was published in August 24th, 2004 in its EJ strategy. So that was rolled back April 30th, 2025. Executive Order 14281 was issued on April 23rd, 2025, and it defines U.S. policy to eliminate consideration of disparate impacts and directs the DOJ to appeal or amend Title VI regulations and to identify similar rules. At all other federal agencies and states, it directs all agencies to deprioritize enforcement of all statutes and regulations to the extent that they account for disparate impacts. That's something that we are seeing right now, that while the Environmental Protection Agency still has the disparate impact regulations in place, we have seen several agencies roll back their disparate impact regulations. Executive Order 14260 is issued on April 8th, 2025. It directs the Attorney General to prioritize identification of state laws purporting to address climate change and environmental justice, and to take action to stop enforcement of state laws that the AG determines to be illegal. So these are all executive orders. They do not have the force of law, but they do have a chilling effect. So this is an executive order that would put at risk potentially state environmental justice executive orders that you'll hear about later today. Next slide, please. So Executive Order 14185, issued on January 27th, 2025, directs the DoD and DHS to abolish all diversity, equity, and inclusion offices, including sub-offices, programs, elements, or initiatives related to race and gender. One thing that has happened with the current administration is that even though diversity, equity, and inclusion and environmental justice, they are actually separate things, the effect of the abolishing of DEI offices has also had the effect of rolling over to reducing and eliminating environmental justice policies. On the Executive Order 14173, issued January 21st, 2025, again, defines U.S. policy to eliminate consideration of disparate impacts. On January 20th, 2025, that was the initial rescission of 60 Biden executive orders concerning climate equity and public health. Next slide, please. Executive Order 14151 issued January 20th, 2025. So the OMB, DOJ, and OPM were to coordinate termination of all DEI mandates and preference and states' intent to formulate new civil rights policies for the executive branch. So there are several actions that would take place after that. Executive Order 14154 issued January 20th, 2025, directs agencies to immediately pause the disbursement of BIL and IRA funds. There have been several lawsuits since the executive orders that have paused funding that was congressionally mandated that we'll also touch on later in the presentation. Next slide, please. Executive Order 14172 issued January 20th, 2025 creates the U.S. Board on Geographic Names and directs the Department of the Interior to rename Denali and other Alaskan landmarks, directs DOI to rename Gulf of Mexico and provide other agencies with guidance on making corresponding changes to maps, contracts, etc. So this is another rollback of the attempt to actually make sure that place names reflect the actual American history associated with them. So next slide, please. On March 11th, 2025, Administrator of the EPA, Lee Zeldin, ordered the closure of the Office of Environmental Justice and the Office of External Civil Rights, the Environmental Justice Divisions in 10 EPA regions, and the Office of Inclusive Excellence. So it followed a February 2025 decision to place 171 employees on administrative leave who have been working on EJ or diversity, equity, and inclusion and accessibility initiatives. So the background to that is in September 2022, EPA launched the External Office of Civil Rights, and it was led by a Senate-confirmed assistant administrator. The new office elevated EJ and civil rights enforcement to the same level as EPA's other major offices for the first time. It merged the Office of Environmental Justice, the External Civil Rights Compliance Office, and the Conflict Prevention and Resolution Center to create the new office. Also significantly, one of the office's first tasks was to allocate $3 billion in the Inflation Reduction Act and climate and environmental justice block grants. So the elimination of these offices, in addition to taking away federal environmental justice infrastructure, also took away the actual office that was meant to administer funds for the Environment and Climate Justice Block Grant Program. Next slide, please. One other significant blow to environmental justice came with the Louisiana versus Calais decision. Political power is incredibly integral to achieving environmental justice. So this year, on April 29th, the Supreme Court issued the 6-3 decision in the case. That opinion strikes down Louisiana's enacted congressional map as an unconstitutional racial gerrymander. So the majority ruled that the map, which created a second majority Black district, violated the 14th Amendment. So this decision significantly narrows the scope of Section 2 of the Voting Rights Act. That is important because Section 2 has long served as the primary nationwide protection against discriminatory voting systems. So I just wanted to raise the issue that the denial of, the subversion of, and the lack of political power are primary drivers of environmental injustice. So when communities don't have representation that takes their concerns to the halls of legislatures, planning boards, and other decision-making bodies, they become invisible or worse, targets for harm. So this decision will make it much harder for vulnerable communities, Black communities in particular, to have their voice in government. So the work that anyone does to prevent, alleviate, or stop pollution in the nation's most vulnerable communities is always significant and is even more so now. So this slide has access to the opinion, some updates from the people who argued that case as well. Next slide, please. So we are in the phase of, figuring out where do we go from here when many federal environmental justice directives have been rolled back. Next slide, please. So some federal environmental justice, legal protections, and organizing protections that can be used to appeal to the federal government include Title VI of the Civil Rights Act of 1964, mapping and data tools, information access, the National Environmental Policy Act, litigation, organizing, and storytelling. Next slide, please. So Title VI of the Civil Rights Act of 1964, it protects against discrimination. So it applies to any program, any business that receives federal funds. So there are two pathways. One is the pathway to court, where intentional discrimination must be proved. The other pathway is an administrative pathway, and that is where historically allowed disparate impact claims would be adjudicated. That has been limited due to executive orders that have spurred regulatory rollbacks. So the regulations, as I said, EPA's disparate impact regulation is still in place. Next slide, please. So Executive Order 14281 is the executive order that spurred many of the regulatory rollbacks that we have seen. Again, executive orders don't have the force of law, but they can encourage or chill action by agencies, and it's meant to eliminate disparate impact enforcement. So that means that it is harder to prove discrimination. There's likely a better chance of success if there can be an allegation of intentional discrimination. So this is a blow to environmental justice enforcement, but Title VI, the statute definitely is still in play. The regulations are what are in question right now. Next slide, please. So mapping and data tools. There are several data tools that are no longer available, like the Climate and Economic Justice Screening tool, like EJ Screen, even though there is a backup version of EJ Screen that isn't updated with current data. But knowledge is power, and it is still important to be able to access these tools. Next slide, please. It matters because the maps actually visualize what the harm is. It visualizes what disproportionate impacts look like on particular demographics. It documents cumulative burdens. It can prove the proximity of communities to polluting sources and show the proximity of new polluting sources to existing polluting sources. It shows demographic patterns and can support permit challenges or comments on permit decision-making matters. Maps can make invisible injustices visible. Next slide, please. So the Social Vulnerability Index, I think, is a very helpful mapping tool that still remains. It is helpful, I think, in the way that the Climate and Economic Justice Screening tool was helpful. It is not as complex. And this is an exercise. When you go back to the slides, if you choose to do that, you can actually use the tool to get more information that you might be interested in finding out. So social vulnerability refers to the demographic and socioeconomic factors like poverty, lack of access to transportation, and crowded housing that adversely affect communities that encounter hazards and other community level stressors. These stressors can include natural or human-caused disasters like tornadoes or chemical spills, or disease outbreaks like COVID-19. So this slide sets out instructions on how to use the CDC Social Vulnerability Index. I think it's really helpful to go to look at an area that is of interest to you and go through the exercise to see what the Social Vulnerability Index reveals. It sets out the overall social vulnerability index, socioeconomic status, household characteristics by percentile. So I think it's a quite helpful tool to access for your own work or to share with others that just may be interested in, what's happening in their county. Next slide, please. So I am based in Chapel Hill, North Carolina. So I wanted to raise the North Carolina Community Mapping System as an example of a mapping system that is still being updated and is available. It includes demographics, health, environmental information like pollution source locations, well water contamination risk. It is updated regularly. So you can see environmental burdens by area, health data by community, as well as cumulative impacts. Next slide, please. Some other national mapping resources that are available include the FEMA National Risk Index, which is now available on the Resilience Analysis and Planning tool. It helps identify particularly disaster vulnerable communities and is helpful for use in resilience zone designation. Historical redlining maps. This is a map from Wake County, North Carolina, and it is instructive just to correlate redlining, which was the prior lawful effort to actually exclude communities from access to federally backed mortgage loans. It is part of the vestiges, it's part of what has led to present day environmental injustice. Redlining resulted in communities not being able to maintain property and led to blight. This is the disinvestment that we see now, which makes communities more vulnerable to zoning changes that can change a residential area to an area that is perhaps light industrial or industrial. So I think it's instructive and helpful information. And then there's the environmental justice state by state tool. It was compiled by a lot of professors. It has information about what each state has available in terms of environmental justice resources, and certainly in an era where federal environmental justice directives have been rolled back, knowing what is accessible on the state level is even more important now than ever. Next slide, please. Information access. So next slide, please. The Freedom of Information Act and State Public Records Acts are integral in order to get information about what's happening in federal agencies. The State Public Records Acts help find out what is happening with the state legislature, what's happening with state level executive agencies. What you can request includes permit applications and decisions, inspection reports, email correspondence, studies and assessments, enforcement records, would find out what types of complaints have been filed. There's all sorts of information that can be helpful to making a determination about whether the government has acted on what it said it needed to do and what the track record has been. So the Freedom of Information Act and State Public Records Acts remain important tools to help achieve environmental justice. Next slide, please. So the National Environmental Policy Act is one of our bedrock environmental laws, and it requires federal agencies to assess environmental impacts of major actions, consider alternatives, and allow public comment. It is a largely procedural statute requiring that there be a hard look at actions that might affect the environment. So there are opportunities to comment on environmental impact statements, to raise concerns during the public scoping process, and to put issues on the record. Next slide, please. So some of the recent changes with the National Environmental Policy Act that have weakened efforts to achieve environmental justice include, first, that the Council for Environmental Quality guidelines on environmental justice are no longer considered. Prior to this change, there was an expectation that there would be an environmental justice analysis and environmental impact statements, and CEQ provided guidance for what that should include. Then the 7-county decision stated that the Supreme Court must give agencies substantial deference. That also is limiting how NEPA is as effective. There are limits on scope. There's no longer must consider upstream and downstream impacts. So it really holds the environmental justice analysis to impacts immediately caused by the disputed project. Next slide, please. I will say one more point on the National Environmental Policy Act before going down this list is that there is a lot of pre-CEQ case law that is still helpful to raise issues regarding neighborhood cohesion, community health. So there's still things in the case law, there's still information, helpful language in case law that go to environmental justice concerns that should not be overlooked. So what still works? Legal tools, citizen suits, other litigation, public comment in the National Environmental Policy Act process, Freedom of Information Act and public records request, Title VI of the Civil Rights Act, data and mapping tools. And on the state and local level, it's important to remember that some states have their own EJ tools, like the North Carolina Community Mapping System, state environmental laws. Virginia has a actual state EJ statute. Local ordinances as well. There's so much action that can take place on the local level to help achieve environmental justice. Next slide, please. So organizing and storytelling, I think, are really significant tools to appeal to federal decision makers and to raise issues. This past fall, Southern Environmental Law Center released a multimedia storytelling project, Plantations to Pollution, Black Communities, Legacy Pollution, and the Path Forward. So the URL is available in this slide. There is also a companion season of our podcast, Broken Ground, that covers the same stories and also has an additional story from the state of Louisiana. And it basically highlights the fact that many Black communities across the South, including areas where Southerners migrated, that they're inextricably linked to plantation slavery. So the multimedia storytelling project profiles 4 communities that grew up in the shadow of former plantations and really highlights the fact of knowing the history of systemic racism and how it relates to current disproportionate burdens of environmental harms on the same communities. If it's not understood, it's destined to be repeated. So the areas that are covered in the multimedia storytelling project include Hayti, the Hayti community in Durham, North Carolina, which was known as one of the nation's Black Wall Streets. It is in the same county as the former Stagville plantation. And many of the Stagville descendants are engaged in present day advocacy regarding the construction of Highway 147 and its aftermath. The storytelling project also goes into the history of the Inslee Bottoms plantation and current day issues in Southwest Memphis, which is the same geographic area. Southwest Memphis has several environmental threats, and they're working through them now. People are organizing in the community to push back against these harms, but it actually shows this story. The Tip Top Plantation, going forward to current day Bucksport, South Carolina is covered. And finally, the historic Buck Road Plantation and now the Virginia Tidewater area is also covered. So I was going to say a little bit more about that just by way of example. Next slide, please. So the predominantly Black Hampton Roads area flourished after the end of enslavement. So on the same site as the former Buck Road Plantation was the Bayshore Resort. So it was a popular Black seaside vacation destination that opened in 1898 and unfortunately was devastated by a hurricane in 1933. This story is not an uncommon story in terms of persistent extreme weather events and Black communities. Flooding there in the Virginia Tidewater region has been exacerbated by climate change. So one of the neighborhoods in that area in Norfolk is the Berkeley neighborhood. And I think it provides a clear example of how disinvestment can lead to land loss and what actions that people can take to actually do something to prevent that and to actually end up protecting a neighborhood. So during recent municipal resiliency planning, decision makers planned to leave the Berkeley neighborhood out of the resiliency planning map. And the reason that it was being left out was because the community was told that the property value of the area that would need to be protected, that it was less than what it would cost to actually engage in the protective mechanisms that needed to be rolled out for prosperity for that area. So the people in that area organized. They showed how disinvestment had led to blight. And through organizing, through an appeal to the Army Corps of Engineers, residents were able to successfully get another feasibility study to protect that community. Next slide, please. I also wanted to talk briefly about federal funding freeze litigation as another tool that remains for environmental justice. So there are, I think, over 300 cases that are that have been filed against the current administration regarding unlawful actions, allegations of unlawful actions. Many of those relate to environmental justice topics. I think this is one that is particularly important to raise. One of the federal funding freeze litigation cases is Sustainability Institute versus Trump. It was filed in March of 2025. The plaintiffs are 13 nonprofits in six cities. The Sustainability Institute, which is the lead plaintiff, it's a South Carolina-based organization. They had funding at risk of $11.4 million that was to be used for energy efficient, affordable homes for people in the Union Heights neighborhood, also a former plantation site where 99% of the community is Black, reduction of greenhouse gas emissions by weatherizing and retrofitting homes, reconnecting the community that was fragmented by construction of Interstate 26. This is a repeated environmental injustice story, communities being fragmented by road projects. So there were Administrative Procedure Act claims in this case that were successful, basically that the actions of the administration to pause and then cancel outright the program, that final agency action was arbitrary and capricious and contrary to law. There were also separation of powers claims. These were funds that were statutorily mandated to be spent in the way that Congress authorized, and that it was unlawful for the executive to come in and make a decision to whole cloth eliminate a program that Congress had authorized. So there was a favorable ruling declaring that the program cancellation was illegal on June 12th of this year, and a motion to enforce the judgment and clarify relief on plaintiffs' claims was filed last week on July 17th. So we're waiting to see what the next step is, but I just wanted to highlight this as one of the examples of litigation that remains to help achieve environmental justice. Next slide, please. So environmental justice, legal, regulatory policy, and organizing tools are still available. Despite federal rollbacks, there's still some accessible data. Plaintiffs can still file lawsuits. Citizen suits are otherwise. Their communities can comment during the National Environmental Policy Act process and other state level environmental regulatory processes. Neighborhoods can continue to monitor their community, to document harm that they see so they can then have evidence to provide to regulators to get actions, and communities can organize. Next slide, please. So thank you for the time, and I look forward to hearing your questions.
Thank you so much, Chandra. That was really insightful, and I know I speak for so many of us that we just admire you and the work that you do. And now we'll turn it over to Stacey.
Thanks so much, Kristine, and thanks so much to Chandra for that great presentation. And thank you to ELI for having me and for all of you joining today. As Kristine mentioned, my practice includes advising companies on incorporating environmental justice into their policies, their procedures, strategic planning, and compliance. And as part of that work, I have the privilege of also working with and collaborating with community organizations, EJ advocacy groups, state agency partners, and former colleagues from EPA to bring together multi-stakeholder solutions. So I flag that as just a grounding for bringing complementary perspective to Chandra's great presentation and thinking about these issues as a private sector practitioner. So over the next 30 minutes or so, I'll just provide a parallel working map of EJ as a legal policy matter from the private sector perspective. And we'll sort of walk through, if we go to the next slide, please. Our first stop is to highlight a few points on terminology as a level set. I think much of the confusion in this space, and I think Chandra touched on this, it comes back to the fact that EJ means different things in different places, in different jurisdictions, in different contexts, and that's all evolving quite significantly now with changes in federal policy. Then we'll take stock of the current landscape, highlighting particularly state expansion and EJ laws that accompany federal change in direction that Chandra highlighted. From there, we'll highlight considerations and challenges for practitioners given this new legal and policy landscape, and we'll close with the road ahead where law and policy seems to be headed. Next slide, please. So let's start with definitions. It's sort of a simple question, or a deceptively simple question to start. What is environmental justice? And I guess everyone in this room who's come to this might have a slightly different answer in mind, and that's precisely the point. I think it helps to understand the origins of the terminology and of the work that we're doing in this space now. For the uninitiated, environmental justice was a product of the civil rights movement in the 1950s and 60s, including the Memphis sanitation workers strike, where Black sanitation workers in Memphis, joined by Martin Luther King Jr., opposed unsafe working conditions. You saw a proliferation in the 1980s, really after first decade of environmental laws, Love Canal disaster, where residents of Warren County, North Carolina, protested the siting of a PCB hazardous waste landfill in a predominantly Black community. This is where environmental racism as a term was coined by Ben Chavis, the United Church of Christ, and that would later become the term environmental justice. We see data development in the 80s following Warren County with reports like Toxic Waste and Race tying the siting of toxic facilities, of hazardous waste facilities to minority communities. That's followed by real galvanization of national action and federal policy action with EO 12898, and more recently, President Biden's EOs 14,008 and 1496, where you start to see real building of capacity building and incorporation of EJ throughout the federal government. And then as the federal government has changed course, states have really stepped in, bringing forward their own laws to define, incorporate, and address environmental justice issues. So now we're here. Get to the next slide, please. So to bring it back, what is environmental justice? Typical lawyer answer, it depends. These definitions vary so widely and wildly by jurisdiction and community. The most trace back to what was previously the US EPA's definition. They use very similar language, fair treatment, meaningful involvement, but who's covered by that language and the way it's interpreted varies pretty widely as well. We talk about fair treatment, we're also talking about not just benefits of environmental condition decision-making, but also burdens. So just for sake of example, I've put a couple of different state definitions up here. You'll see New Jersey has the traditional fair treatment and meaningful involvement of all people, regardless of race, origin, or income. Virginia's twist on that adds faith and disability. And Washington builds connections to specific and concrete applicability to development, implementation, and enforcement of laws, rules, and policies. So these are nuances. They're not footnotes. These are really fundamental changes and different distinctions in terms of who counts as an impacted community member. Could be for permitting purposes, for funding purposes, depending on the state. The practical takeaway is that given the change in federal policy approach, we can no longer rely on a single internal EJ definition or compliance checklist. The statutory triggers really differ state to state. Next slide, please. The definition, beyond the definition of environmental justice, the definition of an impacted group, if it's a overburdened community or a disadvantaged community, varies just about as widely as the definition of EJ itself. Some states rank census tracts by percentile on a composite index. So a prime example is California. It ranks census tracts with a score and then takes the top 25% as disadvantaged. It's relative, it's not absolute, and it adjusts over time as data updates. Other states set a fixed thresholds, identifying communities above a set poverty rate or pollution burden threshold. One example is New Jersey, which sets flat numbers and identifies overburdened communities as those above 35% low-income households or 40% minority households or 40% limited English households. Those tracts that cross the threshold qualify without it being comparative or relative system. And other states blend. New York has tracts by percentile like California, but separately qualifies individual low-income households, making the cutoff. And in other states, there are more qualitative definitions. Like in Washington state, the definition of an overburdened community is fixed on geographic areas where vulnerable populations face combined multiple environmental harms and health impacts, not limited to highly impacted communities. So there's flexibility there and a little bit of uncertainty, not only for regulated entities, but for communities in navigating this landscape, because there are so many different definitions state by state. To add to that, there are also long-standing practices predating many of these laws, which really started to build in 2020, amongst and between advocacy and community organizations who talk about frontline and fence line communities, which is an important point to keep in mind when you're engaging with stakeholders who may not think the regulatory definition is sufficiently comprehensive, particularly if it doesn't include their community. Next slide, please. With these definitions, let's sort of use that as a level set to say it's clear as mud. Let's look at where things actually stand now. So as I mentioned, since 2020, there's been a growing number of states that have adopted formal statutory or regulatory environmental justice frameworks, and this has continued well after even federal policy has reversed course. So the headline here is really the divergence, federal policy moving back, but states moving forward, including some of the largest economies and in the country, including California, got New York and New Jersey. Many states have adopted permitting review requirements and cumulative impact assessment mandates. And last July, in proactive defense of many of these laws, a coalition of state AGs put out joint guidance specifically affirming that they had the legal authority to continue to introduce, implement, and enforce these laws. The state mechanisms vary from permitting review requirements to cumulative impact assessments to funding eligibility conditions and other requirements. As far as permitting, New York and New Jersey are prime examples. They give environmental agencies permit denial power, not just a review obligation, and this is really the strongest form of the tool and presents for many of my clients the largest challenge in terms of building out project timelines and really figuring out how to do this analysis in earnest. New York's version goes pretty far in terms of covering permit renewals and modifications and not just new projects, which is the focus for, which is where New Jersey's allowed to make those EJ-specific denials. So these are real operational consequences, really concrete stakeholder engagement obligations, project impact analysis requirements, really have implications for operational continuity and really force focus on the analysis in these states for permitting purposes. Cumulative impact laws look at the existing pollution burden on a community, not just the new projects incremental contribution, but a broader analysis of the aggregated impact on a given community. Minnesota and New York are prime examples of state EJ laws with cumulative impact components. The New York EJ siting law is a real focus, I think referred to as the cumulative impact law, and requires the lead permitting agencies to consider whether an action may cause or increase disproportionate pollution burden on disadvantaged communities. And the state environmental agencies require an existing burden report to assess those burdens before permitting. So really, again, concrete obligations here. Funding eligibility laws include California and New York, and just highlight California's SB 535 is a cap and trade program that distributes proceeds on disadvantaged community status. So at least 25% of funds are set aside for disadvantaged communities as defined by CalEnviroscreen, which is the state mapping tool. And that applies across dozens of state grant and incentive programs. It directs public money to particular communities, which in many cases can be a little easier to move forward than the permitting denial power approaches. So bottom line, there's a diversified and growing level of activity at the state level to build out legal authorities and EJ infrastructure, regardless of what we're seeing at the federal level. We can go to the next slide, please. Interestingly, alongside state developments, it's worth flagging that while federal policy shifts are sizable and reversing course in the last couple of years, EJ-related concepts are not completely absent from what we're seeing in terms of federal policy direction. And there are several initiatives that share goals with traditionally EJ-focused and EJ advocacy organization goals. While the term environmental justice has clearly been eliminated, concepts are not completely distinct. I'm sure there is skepticism in response to this point, but I think a primary example of this is the May 2025 MAHA report, which has a dedicated chapter on the cumulative load of chemicals in our environment. There's repeated emphasis from this group in this report and more broadly on the emphasis of vulnerable individuals and populations with respect to health, a focus on addressing interacting stressors, focusing on accumulation of exposure over time as a way of measuring impacts and burdens, and particular advocacy on issues that I think have long been the focus of environmental justice advocates. Safe drinking water, expanding PFAS regulation, lead exposure reduction. So there's some interesting synergies in terms of what we're seeing for federal advocacy that may not be called environmental justice, but does have some overlap. Next slide, please. Alongside, and perhaps in response to the shift in federal policy, we're also seeing a shift in advocacy efforts at national nonprofits, EJ advocacy groups, and community organization levels. While 5 years ago, a lot of this advocacy was at the federal level, the focus on the WEJAC and Justice 40 and federal grants, we're now seeing a lot more activity at state and local levels, project by project, through legislative advocacy, and increasingly through land use and zoning fights. Data center opposition is a good example. It's showing up as an environmental justice and cumulative impact issue in many local siting battles, which is to some degree sort of back to basics land use territory for more traditional EJ advocacy strategies. We're also seeing increases in community generated and citizen science data, which I think Chandra pointed out pretty well, which is raising interesting questions about how that substitutes or complements, manages the gap now for federal data tools. After 4 or 5 years of increased funding and collaborative efforts in developing the WEJAC, we're also seeing broader coalitions form between local advocacy groups and national organizations, including results of pooled resources, capacity building, and shared legal strategies. So that's really, I think, brought some more sophistication to the conversation and the opposition back and forth between that might have been more isolated in certain communities is now, I think, a broader conversation. In addition, with the advent of these new EJ laws state by state, with more mapping tools and with broader collaboration, you see a lot more expansive and creative litigation strategies, including novel applications of new state statutes. So it's really a much more complex environment for lawyers and beyond to think about how the advocacy community is also getting involved in these issues in response to change of course in federal policy. Next slide, please. At the same time, many of these EJ-focused nonprofits and organizations are facing significant pressure from these policy shifts and have been targeted in certain ways by the federal government, including tax-exempt status scrutiny, termination or suspension of federal grants, facing False Claims Act and certification exposure, including for those who are government contractors, facing governance and fiduciary duty challenges, and investigations and information demands that soak up resources that many organizations don't have. So in response, from 2021 forward, we've seen a real build in defense infrastructure for these organizations, including pro bono legal networks that refocus not primarily the historically traditional advocacy or EJ-focused goals, but more on NGO and tax-exempt nonprofit governance and advocacy and defense, more helping on issues like governance, board management, operational resilience, and grant compliance, really complicated issues that many of these organizations don't have the resources and expertise to manage. It's really particularly complicated. So this is really building back capacity for many of these organizations that were facing a bit of an existential crisis at the beginning of the change in administration, expanding governance capabilities, and also offering opportunities to those of us who don't typically work in this space to support these nonprofits in a novel way. Next slide, please. So given all this change, what does it mean for practitioners? What questions are raised? Otherwise said, what do we do in a world without EJ screen? A lot of programs, state, local nonprofits, even internal industry screening tools are built on top of EPA's mapping infrastructure. Without that foundation, many of these programs don't automatically have a replacement. So there's a question of what tools do you use? What do you use a state tool? Do you use a maintained version of EJ screen? Do you use citizen science? It's really raising a proliferation of questions, and many of the answers are certainly case specific, but this is a really pervasive question now for the work that we're doing day to day. Next slide, please. In addition, as a private sector practitioner with many clients who've leaned very far forward in good faith to build EJ programs, both before the Biden administration and after, we're frequently asked about the tension between federal scrutiny and state compliance. There are many of these states with EJ laws and requirements. This is just baseline compliance. You need to work with these state laws, but there's federal political pressure pulling in another direction, as well as existing community relationships and commitments that sit somewhere in the middle. So quietly stepping back from EJ commitments that have already been publicized also carries reputational and sometimes legal risk. There's just not a clear answer on those trade-offs. So that balancing of risks is a everyday question, I think, for many regulated entities, especially those with a presence in states with active environmental justice laws, to try and figure out the balance and play the long game in terms of how they balance equities, relationships, reputational issues in the long run and the near term. So let's close by looking at the road ahead and make sure if there are questions. We've left a little bit of time. So I think we can expect to see new state EJ laws continue to move through implementation, rulemakings, and enforcement. This is definitely not a static area. Multiple states have pending EJ bills, particularly Illinois and Virginia have some concrete examples to track. Minnesota's cumulative impacts rulemaking is worth watching to see how that moves forward. And model legislation is also in development. We Act and Columbia's Sabin Center are developing model bill language, which is usually and can be a sign of where states will land over the next legislative cycle or two. Next slide, please. In addition, many multinational companies have a footprint in the US, but also have a footprint in the EU. The EU's Corporate Sustainability Reporting Directive, or the CSRD, may have EJ relevant reporting obligations through ESRS S3, which is the standard on affected communities. So under that standard, if a company determines that there are impacts, risks, or opportunities related to affected communities and that they're material, it must report on those positive and negative impacts of its operations and what actions it's taking to prevent, mitigate, or remediate them. This, for these global companies, this could be a question of what do most domestic EJ-related issues rise to the level of materiality? How does this reporting actually impact these companies? So that's something to watch as CSRD implementation moves forward. Next slide, please. And just finish out with, just key takeaways. Environmental justice is clearly continuing to evolve in this new policy environment. There are near-term challenges and opportunities, but it's still very much alive and active and moving forward. For regulated entities, there are really meaningful compliance requirements in many states and new litigation vulnerabilities, as well as existing stakeholder-related risks and tensions with federal opposition. So it's not as easy as just sort of stepping back and changing terminology, but thinking really broadly about compliance and enforcement exposure, as well as continuing to build relationships with your fence line communities. And finally, for this broad cross-section of attendees and practitioners, there are certainly new opportunities to explore EJ in whatever work you do, wherever you sit, if you're in litigation or regulatory work and enforcement or transactional work, including nonprofit governance counseling, helping with compliance and state laws, and then working in developments of new model legislation. So it's a pretty broad landscape that offers lots of opportunities to get involved. That I'll pass it back to Kristine.
Thank you for that, Stacey, and thank you again, Chandra, for your insights. All right, to our audience, if you have any questions, please put those in the Q&A, and we'll start taking the questions now. So this first one starts off with big fan of your work in the EJ space, so I think that's always nice to hear. That they ask, what words of encouragement do you have for communities and stakeholders alike in the wake of kind of stepping back from EJ in the federal space? And then especially when utilizing those noted tools in the presentation, I think this is talking about your presentation, Chandra, how can we continue to inspire hope?
I'll start. So one thing that inspires hope for me is the fact that we're all worth it. And I am still inspired to do all that I can to have, the best conditions for myself, for my neighbors, So even in the face of rollbacks, that doesn't mean that suddenly we don't have need, and that there aren't issues to be addressed. So we're a bunch of professional problem solvers with tools that can, improve people's lives, that can help them live the way that they've envisioned for themselves. So I continue to be inspired by that. I think in this era, it's always another place to create hope is like looking for strategic alliances across sectors. Their attacks on diversity, equity, inclusion don't just harm efforts to improve public health or protect the environment. They also, I think, result in, lack of protection of disability rights. There are veterans that have, specific protections. And some of these attacks on diversity, equity, inclusion will actually make it much more difficult for state agencies, for federal agencies to actually comply with existing legal obligations. So we would like to, I would like to see, and I think it is a source of hope, to form alliances across sectors, look for ways to rebuild. A book that I think is very interesting is called How Equality Wins. So two law professors wrote this, and it really gives, I think, some instructive things to think about. One of them being like, let's consider what it means to broaden the tent of, who is included. And I don't think that is harmful, because one of the points it also points out is that one of the points that it also illuminates is that we can still triage in certain spaces, that everyone can be harmed by, the environmental pollution, for instance, but we can just see by the data that some groups are more harmed than others. Let's triage. Let's make sure that communities that are the most vulnerable are getting attention. And I think that is also across sectors. So let's look at the data, see where most of the harm is, include people in this equality tent, and go to help those who need the most help first. So that's a long answer, but I'll stop there.
Thank you. Can I have you repeat the name of the book again? Someone was asking in the chat for that.
How Equality Wins.
Thank you.
I think it was an inspiring answer. I always go back to, I have a professor at Howard. He used to be the chair of my former law firm, Ben Wilson, say EJ didn't start at the federal level. It built from the grassroots, from communities, and evolved to something that became federal policy when there was enough gravity, momentum, and hard work and data to build policy. And the law sort of reactive in that way. It builds over time and adjusts slowly. So I think, trying to keep that perspective and recognize there are a lot of ways to do this work. It's not just, getting a definition in an executive order, which is huge, but there's lots of ways that have practical impacts, including, I tell myself, and I have a lot of friends in the nonprofit and community space who tisk at me, but including working with many companies to try and think about how you incorporate environmental justice on a day-to-day basis on projects. So I think there's lots of ways you can do this work, and it's not just federal policy. So that's what gives me encouragement.
Thank you both for those answers. And again, if you have questions, please pop them in the Q&A. Our next question, I think we can look at kind of from a day-to-day in your work. How have these changes impacted, how you're working? Are you now, you both mentioned how you're using different instruments, different tools in this new landscape, but is it forcing you to be more creative as you approach a problem? Chandra, you mentioned a big tent approach. Stacey, I know you work with regulated entities, but thinking, kind of as you approach it day to day, how has it shifted from the rollback to now?
Well, you're more in the trenches than I am, Chandra, please.
So this era, I have to say, was incredibly jarring. So I've been an attorney for 25 years. 20 of those years have been in the practice of environmental law. I came to SCLC knowing that I was like, this is the organization that I'm going to be able to deliver services to the most vulnerable communities with practitioners who are very passionate and skilled in environmental protection. And what I'd seen was, a very slow gain in acknowledgement of environmental justice, slow progress and repair, and to see like just an incredible, um, incredible rollback that was so fast. It is jarring. That is the way that I describe it now. So to see this happen is it's astounding. Now, at the same time, I still see that communities are organizing. I am still very much motivated by younger people who are saying, not only do we demand environmental protection, we demand, we think that corporations can also do the work before having, a regulator say it. So I think there's more action in the stakeholder space as we look at the regulated industry that people, expect and should expect that profit can exist alongside with sustainability. I think that we can all acknowledge, like, yes, we need services, like we need reliable electricity. We need products that sometimes involve some level of harm, but there's also innovation. How can things get done in a way that creates the least amount of harm, that is protective of the communities that are, in the same watershed where there are discharges of contaminants to our water bodies? We can look to the regulated community to, say, let's have another layer of consideration in how we operate, which is sustainability, which is being a good neighbor. And, I think that we have allies, like particularly really young people who just expect the best across the board. And I appreciate I appreciate being pushed in that way and reminded, like, no, we don't, it's not just one or the other. It's not jobs or the environment. It is imperative for us to think about how to do everything in a way that is protective of people and the environment, and we still get the services that we need to function as a society.
I totally agree. I think I was fascinated by, I started doing this work in the private sector after I left EPA in 2017. And so we started the practice in the first Trump administration. And it was a lot of focus on 101, sort of getting to the basics, understanding the concepts. And then with the Biden administration and the huge explosion of focus with the IRA and the giant carrots of the grants that were at issue, the genie was out of the bottle in terms of motivating huge numbers of people in regulated industry and beyond to understand what is environmental justice, how do we implement it, how do you distribute benefits in a certain way, how do you assess target communities. And I think the skill building there and the conversations that are being had in-house don't stop just because the policy changes. So I think there's, it might be a different prioritization and risk calculus in terms of what you do first and how you do it when, but those partnerships and relationships that were built, that Chandra was mentioning, I think with the IRA particularly, built a lot of coalitions. There's just, I think some of that just has shifted fundamentally from this being like EJ being a nice to have ESG sustainability component to being something that's more fundamentally taken seriously, particularly where there are state laws. EJ is compliance. It's not nice to have. So I think that has been a really significant change.
Thank you both. All right, now looking at one of our next questions, thinking about the gap with EJ screen. Is this something that you think academia can fill? How do you see, I'm bringing some other parts into this question, but looking at environmental clinics at law schools, how do you see kind of academia helping fill the voids that have been left? And, what is their role in this with EJ screen and then also in other areas?
So I can start. So in fact, there is a shadow EJ screen, like, so that is being maintained like in collaboration with some people in academia, some people in nonprofit space. it still is not updated in the same way. That is actually a function that I have not seen it being taken over like whole cloth, that it is going to operate in the same way that it did when it was a federal imperative and when there were federal taxpayer dollars. So there, yeah, I think clinics have done, wonderful things. Like definitely there are clinics that are tracking litigation happening across the nation in the environmental space, and just tracking the administration and what's happening with so many executive orders and allegations of illegality. I think that universities have also taken a hit. Universities have received a lot of grant funding that has also been called into question by attacks on diversity, equity, and inclusion. That money actually helps them they're funded to do their work. I don't know how much their endowments can, fill in the gap between what they were expecting with federal aid that has been, that was paused or in question. I do think that we should look toward building back, that we shouldn't, forget that there are pieces of legislation, there are bills that have never made it across, to passage, but the Environmental Justice for All Act, it still exists. We're going to be looking to build back voting rights legislation. And I think we should be also looking to build back these federal tools that are supported by federal taxpayer dollars, that we should have the expectation that we have not reached a new place that will be forever the norm. So yes, I think academia can help, but I think it is reasonable to have the expectation that taxpayer dollars should be spent in the ways that taxpayers support, which include us having access to data. That is, public data that we contribute to. We should continue to have access to it. So I'll stop there.
And I would say, I think there are also still data sets that are available that are not, because EJ Screen was an aggregation of publicly available data. It was a magical, useful thing. But there are also GIS data sets that can be leveraged in other ways. I agree with Chandra that I think there has been a gut of resources for this sort of thing, and perhaps deprioritize motivations given all the other things that universities are facing and challenges that they're facing. So not being in academia, and I don't have as close an understanding of how that all gets weighed out. But I do think there's certainly conversation of how, regulated entities have policies that say, hey, we're going to use EJ Screen to do XYZ, or they want some way to uniformly look at impacts. And having a tool like that, there's, I think, some appetite in the absence of federal leadership to have an organization, a think tank, whatnot, put together guidance or some sort of resource using the data that is still reliable and federally available. So I think there's that piece, but there's also obviously plenty of state tools, and I think those are continuing to proliferate and be developed. So that's something that, at least in the interim, is a reliable backstop.
Thank you both. And then I know that you touched upon this in your presentations, but talking about some of the developments at the state level, would you like to maybe spend a little more time maybe highlighting one or two states that you think are doing exciting things that might be able to be replicated in other states in the EJ space and legislation?
Yeah, I mean, you want to go first, John? No. I think, New Jersey is clearly, the first of its kind in breadth that is the furthest ahead. I think keeping an eye on some of the, new political leadership, looking at how that ends up playing out, what sort of enforcement we see, sort of tracking more closely permitting outcomes and how these analyses play out. I think Virginia is a fascinating place. We've already seen projects kind of bump around a little bit with their EJ law. Again, new political leadership in a state that swings a lot of different directions. I think that will be and with a huge amount of data center development, that is going to be a really important place to watch how EJ laws are put into practice and enforced.
And I'll say that the state by state EJ tool, is a great source of information about state EJ laws, state EJ executive orders, state mapping tools, state assessments of cumulative impacts. It's a great place to look. So I can't tell you the number of EJ laws, but the state by state tool gives you so much information on that topic. And I think the AG letter that Stacey mentioned, I feel like it's like 13 AGs that signed on to it. I could be wrong about that number, but that is also in the materials that AG letter that came out last year that's helpful, that is talking about like, here are all the ways that state AGs are working to support environmental justice principles and to achieve environmental justice. Unfortunately, there were no Southern states on that letter, but I do know, North Carolina has an environmental justice executive order. We still have a state level basically group of people who are charged with implementing that executive order, and like including the cabinet agencies. And like Stacey just mentioned, Virginia is also, there's that state statute. There's implementation of the state statute. They have a state council as well that's charged with basically making sure that the state is, doing something to help achieve environmental justice. I think that, there are disappointing actions in Southern states that we've seen in the aftermath of Louisiana versus Calais. But, we also saw that, the state of Virginia said, we want something better. There was a flop back in that same state. But I guess I'm just saying, like, we saw Memphis, crack the only majority Black district after Louisiana versus Calais. That is disappointing. There's still work to do. North Carolina has been gerrymandered so much. There will not be any more changes to our congressional maps right now. I think everybody's just kind of looking forward to the future and what's going to happen next. But yes, please check out the state by state EJ tool to get just more in-depth information on that question.
Thank you. And then in your answer, Stacey, and someone is also asking about this, but the connection between data centers and EJ and kind of the space that EJ, that there's going to be a space where we need more EJ protections, legislation to really address what's happening. Do you see this in either of your work, or do you have thoughts on this new, I don't want to call it a trend, but this new emerging issue?
I think it's a fascinating topic because there's so much to weigh and consider. New York's moratorium is a really interesting place to start and see how that plays out over the next year. Moratorium on data center development and their analysis on potential impacts. As I mentioned, Virginia is also obviously a hotbed of this activity. So seeing how the EJ laws leverage these both states with environmental justice laws and heavy data center development. There's obviously the XAI litigation in play, seeing how that proceeds and how federal government intervention is a piece there. So really complicated dynamics here. I think the principles fundamentally are the same: impacts and mitigation and which communities are impacted and whether that's disproportionate. So I think same themes, different scenario. But I think another interesting piece here is the local ordinances. We saw some of that with carbon capture on both sides of the political aisle in various states like Indiana. It'll be interesting to see how much, including in places like in states of all political affiliations, how local ordinances and local laws and land use restrictions end up playing more into this conversation on a granular basis as opposed to big state moratorium or litigation.
Yeah, and I'd add, so one of the tenets that we all, I think, look back to is like meaningful involvement. What is happening, what we see over and over again are these, institution of moratoria. I think the last time I checked, it was like 122 moratoria have been issued nationwide. And people they want more information. They want to actually be meaningfully involved in the decision-making process about whether or not, their community can actually sustain a data center. Like, what does that mean for water? What does it mean for electricity rates, what does it mean for what the landscape will look like, where that facility will operate if it gets up and running. So that's where we see like the Freedom of Information Act come into place and state public records acts with communities asking for more information about what is being proposed, because it's not always very clear from the outset with data center proposals what the true cost is going to be of that facility being in the community. But and there's a lot. I think there are like 32 moratoria of the 122 are in North Carolina. There's something to be said about what's happening in organizing here on that issue. But people want more information, and they're finding ways to get it to make the best decisions. The XAI litigation in Mississippi is, I think, what we expect to have the hearing this fall, and really just making sure like these facilities should be regulated as the Clean Air Act requires, and that I think is a fundamental priority, since we have this bedrock environmental statute that's meant to protect air for all of us. So yeah, there's action and so many events unfolding and at breakneck speed in this arena. So see what's next.
Thank you. And then jumping around, looking at our next question, this audience member is asking about structural changes you'd like to see in the federal law that could help prevent these types of rollbacks in the future. So what would you suggest to help really enshrine these that could prevent potential rollbacks? They suggest, for instance, with building on the 14th Amendment and Equal Protection Clause to embed EJ in a federal definition, help with this.
I mean, getting Congress behind it, and the EJ for All legislation that cements a concrete environmental justice framework, I think is something that environmental justice advocates have been pushing for many decades before I started practicing in this work. So I think that's always been a major part of the challenge, is that there's no federal environmental justice law. And we're saying that in almost every presentation I did for like 5+ years. But there's, XYZ, there's the Equal Protection Clause, and there's, every environmental statute has something you can hang a hat on. And EJ 2020 was the EJ Plan 2020, I would be in trouble with my former EJ colleagues, former EPA colleagues, for getting the EJ Plan 2020. But it's guidance document from EPA's Office of General Counsel that walks through each individual media statute and highlights the toeholds for environmental justice advocacy. So I think doing that sort of analysis too, where there are pieces of individual regulations and existing statutes that can be tweaked, modified, strengthened as well, is another avenue beyond far-reaching federal legislation or constitutional amendments, which might be a tall order in this day and age.
Okay.
Chandra, I feel like you have the answer. Yeah, the federal magic bullet. Only.
I do not.
All right. And then I know that many of our audience members are, recently graduated from law school, newer attorneys. And so I'm going to tweak this question a little bit, but really, how do people entering the, field of law, maybe it's not going to be their main practice area, but how do they incorporate EJ into the work they do? How do they, get involved with issues? The question was really asking about how, Stacey, how you've built your role in working with companies and still do EJ work. So really, like, how do these young lawyers incorporate EJ into what they'd like to do? And I know that's a very wide field because they could be doing anything under the sun, but just any tips you have for people just starting out.
Yeah, I mean, I think the fair treatment and meaningful involvement piece, this is stuff that, I went to Howard Law. So at Howard, you're told that you're a social engineer, a parasite on society. And the takeaway there is you think about the good that you can do from wherever you sit. And the bottom line is the role that I have, I'm an advocate for my clients. So no matter what, I'm advocating for their interests. But I do fundamentally think that, as Chandra was saying, doing good can have incredibly beneficial outcomes for companies, communities, organizations, and that there's a sort of interconnected multi-stakeholder dynamic for so many things that folks want to get done. So proactive engagement, I think this came across in some of the IRA programs, was this proactive stakeholder engagement, thinking about impacts, getting ahead of that is so much better than being in litigation later or facing enforcement or having to fight to get your permit passed or having to fight investors with activist proposals. Like trying to think and forecast and lean forward on these issues. It's not a billion-dollar enterprise to do so in all cases. This could just be modifications, mitigations, investments in a relationship. So I think in terms of I'm going to ask the question, how do you sleep at night piece, where it's like, I think the environmental justice piece here is that there's a role to be played at any table in this conversation, and that those different perspectives are essential to actually making progress in this space, to get all the stakeholders around the same table and talking to each other to try and find solutions. Which is to say, if you're doing transactional work and contracts or nonprofit work, or you're a litigator, like there's billions of things that you can do in any particular way to support organizations that are doing this work, to get involved in environmental cases where you're raising points that flag environmental justice equities or vulnerabilities or risks, proposing that a particular client engage with communities instead of rolling the dice. So I think there's lots of different ways to do this work creatively, no matter where you sit.
Yeah, and I think one of the other things that you mentioned is like where attorneys are not conflicted out, like advising the organizations is so helpful. I mean, I think it has been important always. Like there are organizations that just need help, like figuring out how to be a 501c3. Meaning, they don't always have to be, but if they're choosing that, they need some help. If they're choosing to be organized in that way, they might need help with bylaws. Like there's that type of advice that helps their organizational structure be less vulnerable or just more durable. That I think attorneys can have a role in. That all attorneys can have a role in, to the extent that that is your expertise, or that you can spend some time reading up on it, get enough expertise to help with these formation and organizational durability issues.
Thank you both. And I see that we're approaching our time in the next few minutes. So I'd like to end on a hopeful or question and also tie this in with any final comments you might have. But one of the questions is asking, I'm not going to say most rewarding project or experience, because it's really, I think of them as a tier, that there are lots of really rewarding experiences you've had. But can you think of a hopeful example that you can leave us with, and then any final remarks you'd like to add?
Yeah, so there are a few things that are very motivating to me. Definitely engaging with neighborhood organizations as they're crafting strategy, like for what they want to see for themselves. And we're in the era of community benefits agreements. Like these are things that may come before a new facility is going to site, or just it's like the community is visioning what it wants. Like it might want a solar array, and it needs to change its local ordinances to make that possible. But visioning with neighborhood organizations and community groups, nurturing colleagues as they grow in their careers is always very rewarding to me. Encouraging people to always remember that we are not just our careers. It can be all consuming, but that this is not all of who we are. So to nurture people to create space for the work, and for themselves. And of course, winning always feels good. Who doesn't want to win, especially when it's for the environment and public health. So those are areas that are rewarding to me.
Thank you. Stacey?
Yeah, I mean, I think the fact that we're having this conversation and that these conversations are continuing is inspiring, because it has been a daunting couple of months, years, decades, whatever this feels. It feels like it's been a while. but it's been a turbulent space for a bit. And to keep having these conversations in practical sense and talking about the concrete realities, I think that's in and of itself inspiring that all of you showed up and that ELI hosted this and that we're all still here talking. And also say, looking to the folks who were there since the inception, the Charles Lees, the Bernice Miller Travis, the Peggy Shepherds who are unfazed and continue on, is inspiring to look at, this is a point in time where this just looks different, and it's an opportunity to get into this work at a time where there's creativity's, at a premium. This is a helpful time to be creative about the practice of law in this space for any client that you're serving, an organization that you're working with. So I think it's time to think creatively and broadly across what it means to be an environmental lawyer and an EJ lawyer now. So it's also inspiring.
Thank you. Thank you, Chandra and Stacey. This has been a really excellent conversation. I can tell from the chat that people really appreciate your expertise and you're willing to share it with everyone. So again, thank you. And Madison, over to you.
I want to give a huge thank you to our expert speakers. Thank you to Chandra and Stacey for your time and willingness to prepare such clear and informative presentations, as well as answering so many questions. Thank you as well to Kristine for moderating and to our audience for tuning in. As we said at the beginning of the webinar, this program was recorded and the recording will be posted to ELI's website and YouTube page within a few business days. You can also find recordings of all of the other summer school sessions on the ELI website and YouTube page. While this wraps up Summer School 2026, we hope you continue to stay engaged with ELI programming. We typically hold around 50 or more events throughout the year, many of which are open to the public. You can find all of our upcoming programs on the ELI website. If you are an attorney who would like a deeper dive into environmental law, we also encourage you to check out our boot camps, which are 3-day CLE courses on the practice of environmental law. Programs like Summer School are made possible with the support of ELI members. Members can attend exclusive member webinars. They also have access to many other benefits, such as our webinar archive, our weekly newsletter, our acclaimed publications, and so much more. If you are not already an ELI member, we encourage you to visit eli.org to join, and membership is free for students as well. Thank you all. Thank you for coming to our summer school programs this year, and we hope you have a wonderful day. We hope to see you at future ELI programming. Thank you so much.